law students, I think before you even go into advocacy, you need to ask yourself, if you are studying to become a lawyer, you ask yourself, what area of law that you think you will end up, practicing as in Malaysia as an advocate and solicitor. And my topic today is actually why litigation. Of course, I'm a litigator, so I can't speak on behalf of lawyers who practice in other areas such as corporate conveyancing, corporate commercial, intellectual property, communication, technology, even for that matter, criminal law, which partially it is, of course, is related, but not the area that I do in general, or even what do you call, let's say, competition law, competition antitrust, or even like what my firm used to do a lot, aviation law and so on. So actually in legal practice, there are actually many areas. And litigation is actually one of the areas. And in general, when you ask a layman what legal practice entails, most likely, if they are a layman, they will tell you either someone that goes to court or someone that witnesses a sale and purchase agreement, because that's what they actually experience. And I believe those who experience a sale and purchase agreement when they purchase a house or they actually sell a house are more likely, those who have experienced such lawyers is more likely than those who has got litigation experience, unless they have been sued or they are charged in court, or they actually engage a lawyer to sue someone because someone owes them money or something like that. So they may not have the idea of what litigation is. However, they may have watched legal dramas, for the US drama. They may have watched LA Law for the older generation ones, and then the later one, you got Suits in Netflix or something. And for those who are fans of the Hong Kong TVB series, along the way, they would have many legal dramas. And most of these legal dramas would focus on litigation because they are mostly series which actually focuses on advocacy. That is, those barristers, let's say they are called attorneys in the US, barristers in UK, or even in Hong Kong, they call themselves barristers. And occasionally you have got a TV shows that shows lawyers or like corporate lawyer, or if you've read John Grisham, there are some of his novels about corporate lawyers. There are some about court lawyers. So people have a general idea. Lawyers could do different types of things. So for those who are present today, perhaps in up to like 90 of you all, not all of you all will end up being a litigator because it may not be your cup of tea. So that's why it is important, at least for myself, as I don't speak on behalf of other lawyers, that I can share why I chose litigation, and perhaps in general, I think why litigation should be an option for law students to consider, or for the young lawyers, when they start their pupillage, or even in their first 3 years of practice, some of them have not decided, what area that they wish to actually pursue. And just a little bit of background. Litigation is just a subset of dispute resolution. In my firm, I head the dispute resolution department. And in dispute resolution, generally we will advise our clients to say that it covers everything, from mediation to conciliation to adjudication to arbitration, because basically we are trying to resolve disputes. But most of the time when clients come to see you, chances of resolving disputes are actually lower than actually they stick to their ground and they want to fight. So if you don't achieve a negotiation, mediation, conciliation, adjudication, or arbitration is actually fighting already. Okay, it's just another form of dispute resolution. Then most people will go for litigation. and how we associate litigation with court, because some of the other means of dispute resolution does not involve court. For example, you can arbitrate a matter if there's an arbitration agreement before you enter into a deal. And it actually provides that if there is differences or dispute, you actually have to opt for arbitration as opposed to filing a suit in court. So for lawyers, we'll say that those would be a case of arbitration, which falls under dispute resolution. And one of the subset of dispute resolution is litigation, which is the most common because, first of all, not all agreements have an arbitration clause. And secondly, not many people or transactions that could afford arbitration because they're generally paid litigation. So most people will end up in court. So as a result, we most often hear about litigation more than other areas of dispute resolution. So litigation perhaps would cover maybe 90 to 95% of all dispute resolution, because from the simplest debt collection to the most complex corporate shareholders disputes, they would feature in court. So that would be part of litigation. And just to share a little bit more, litigation would be different, in a different jurisdiction as well. And I believe that there are some Malaysian law students here. There are those who are studying to become a UK graduate as well, because either you're doing a twinning or you are planning to study in UK. And I was told that some of those who sign up are actually even from UK University now, but perhaps they are sleeping. They may have missed the session now because it's actually 3 a.m. Unless you show of hands, you're actually calling in from the UK. So there are those who are studying to leading up to a UK law degree. So I can tell you some of the differences. In the UK, litigation covers both barristers and solicitors. For barristers, generally, 99% of them would do litigation. But there are barristers who are arbitration barristers, which is part of, like I said, a general dispute resolution, sort of like a subset of dispute resolution. But generally, barristers will go to court. That's why they are called court lawyers, barristers, and they generally practice litigation. But having said that, even the solicitors, those that lawyers that practice from a private law firm, like the Magic Circle in the UK, like Clifford Chance, not Herbert Smith is actually a litigation predominant firm. Clifford Chance, Allen Overy, Freshfields, this is our Magic Circle in the UK. They do have strong litigation department, but I think some of us, for those who are in more advanced years in their studies, maybe if let's say you're in your final year or you're doing your CLP or your bar, you will understand that in the UK, the solicitors may not have the full right of audience for all cases. So when you go to the highest level, they are usually argued by barristers. So those solicitors who are litigation solicitors are generally solicitors instructing barristers. And the barristers are the one that practices litigation. They are the ones that practices advocacy in court. But the one that generally who sources for clients, the one that prepares the documents, they are litigation solicitors. So that is the difference between in the UK and say in Malaysia, because in Malaysia it's what we call a fused profession where we have advocate and solicitor. I'm an advocate and I'm also a solicitor. I can practice corporate, I can practice other areas of law, and I can also do litigation, and I can appear before the courts up to the federal court. So in Malaysia, it's a fused system. However, there still remains in the Commonwealth jurisdiction a separate profession, For example, in Hong Kong and Australia, they are still like the UK. So you got the barristers who can actually do their advocacy in court, and generally up to the, not the highest court, the lower courts, the litigation lawyers from solicitors firm, they can actually appear as well. But things which are slightly more complex, there is a general belief that the barristers are supposed to be more competent to actually do the arguments before the highest courts. For example, in appellate courts or even trial. Generally, the trial lawyers are barristers in the UK, in Australia, or even in Hong Kong. But in Malaysia, because it's a fused system, well, I'm an advocate for a fused system, because I do discuss with my fellow colleagues in the UK or even Australia, or my friends who are barristers or litigation solicitors in Hong Kong. I'm always an advocate of a fused system, because I feel that the Malaysian lawyers and the Singaporean lawyers, which is similar, we are more diversified. We are able to get clients, we are able to do good drafting. And at the end of the day, we are also trained to do advocacy up to the highest court. Unlike some of my peers in Hong Kong or some of my uni mates in the UK or even in Australia. But to them, they would feel that it has to be separated. Why? Because specialization. They said, if you are a court lawyer, you should not be spending so much time trying to entertain clients or trying to pitch for work. You should leave it to the solicitors, and they would instruct us who are specialists to go to court. And for some of the initial drafting, they too feel that for drafters, you get specialist drafters who are solicitors. But once everything is drafted and is being edited or being corrected by the barristers are the one that takes the brief, they call it, and go to the court and argue before the High Court, the Court of Appeal, or the House of Lords in the UK. So they feel that you need people who are specialized in this field to do what they specialize in. And they feel that Malaysians are like, wow, we are too rojak, we go to court, we get clients, we do the drafting, we have a fused profession, we are they just couldn't comprehend it, because in the UK, they feel that if you are a barrister, that means you don't go entertain your clients, and during the old days, perhaps now, they are getting more fused, so to say, because there are some barristers going outside. And I know personally some Queen's Counsel in the UK. They also go for conferences. I meet them. They do market their services as well. So times have changed, with globalization. Times have changed because they try to market. Even barristers try to market for Asia Pacific's work, even though they are based in the UK, because there are big international arbitration where the seat could be in anywhere else in the world. They try to get a piece of it. So they do market. So they are doing solicitors kind of work as well. So times have actually changed. But in the past, if I speak to a barrister, they will tell me that, stick to what you are supposed to be good at. So it's actually quite embarrassing if you tell, let's say, a very old school barrister to say that, oh, actually, I'm a Malaysian litigation lawyer. I actually go to court. I have a portfolio of clients myself, and I do all the drafting. And then they'll say that, hey, you are just a jack of all trades. You don't have a specialization, which to me it may not be absolutely correct, but there are some truth in it. Because in Malaysia, even in practice, there are different levels of size of firm. You've got the sole proprietor, you've got a partnership of 2 to 3 lawyers, you've got a medium-sized 10 to 15, you've got slightly large, medium to large firm, which my firm is, with like 30 to 40 lawyers, and then you've got a large firm from 80 lawyers and above. So in those large firms, they can practice specialization. That means litigation, that means just strictly litigation lawyers. Corporate conveyancing, just strictly corporate conveyancing. IP, just strictly IP. Competition, just strictly competition. Aviation, just strictly aviation. TMT, just strictly TMT. So only large firms can afford to do specialization. Whereas if you're a sole proprietor, or if you're a small firm, you obviously would be, a textbook fields profession. You can do conveyancing you can go to the court in the morning, and in the afternoon you do conveyancing, and at night you go and do entertainment. You know what I mean? So they will be jack of all trades. They run a firm by themselves, which to me, to some, also it is actually a privilege, because you are your own boss and you just decide what you want to do, and nobody can stop you because there is no restriction of what I can do in terms of practice. So that is the advantage that we have, those separate legal profession in the UK, Hong Kong, as well as Australia. So Malaysia and Singapore is quite similar. We can do everything. And it's only when the firms gets larger that you can get to specialize. So my firm is a firm of a size that we can specialize, and I have been doing litigation all my life, or rather dispute resolution, because I do all kinds of dispute resolution. So now, as a matter of background, and to take time, because actually 2 hours, just going through, or why you want to become a litigator, is too long a time, But it's good to know about the background of why litigation, and what is litigation to begin with. It is, to litigate. In Malaysia we call ourselves advocates. So loosely we say advocates are the ones that go to court. Solicitors are the one that stays in the office, not soliciting for work, but they are solicitors. So they are advocate and solicitors. And in the UK, they are barristers and solicitors. In the US, they're called attorneys. And for litigation lawyers, the US clients will tell me they are trial lawyers. So they are court and trial lawyers, and they have sort of like, they don't call it solicitors, they're called attorneys, who are like corporate attorneys or trial lawyers. So when I dealt with the US clients, they sometimes would also be quite surprised that when they instructed me, let's say a multinational from the US instructed me from the very beginning. So when it goes to trial, some of them will write to me to say that, okay, is it time for us to start engaging or talking to trial lawyers? They said, no, in Malaysia, there's no such thing as when you go to court, you engage a trial lawyer. I am your trial lawyer. And then, you see shocked in their faces, because they're saying, you are the one that I spoke to from the very first moment I contacted someone in Malaysia, and I told you every single fact and evidence of this case, and you have been liaising with me, you have been billing me, and so on and so forth. Then now we move to the next stage. We need to go to court. We need to prepare witness statements. We need to interview the witnesses. You're telling me you are also doing it? And I say, yes, in Malaysia, that's what happens. We don't engage a trial lawyer because we are advocate and solicitor. Then they'll be a little bit skeptical, until you send them some articles. You need to convince them. In Malaysia, we are also quite different from the UK, Australia, Hong Kong, which even a US client thinks that we are still similar. They're expecting us to say that we will be engaging a barrister when we go to court. So it's all the expectation from different parts of the world in different jurisdictions. Okay, so this is a little bit of background, and now I'll go into some of the pointers that I've actually prepared. I'll start off with why should someone be a litigator? Becoming a litigator. Of course, there are some of the things which are quite noble, like the ability to help others. I think by now you would have reckoned that, if you want to do legal aid, for example, for those who have started their pupillage, after their bar school, there is one option, or is it an option now? I'm not even familiar now. I think it's compulsory. You have to do legal aid. And to do legal aid, generally it's only the litigation lawyers who can do legal aid. Generally, I'm saying generally because perhaps 99% of legal aid would be required of a litigator to assist those people in need. For example, the poor people who are being charged or falsely accused, for example, or maybe they may have a defense of mental disability, but no one is there to help them. So for the pupils, when after you finish your bar school or your CLP, when you start your pupillage, you may be mandated to do some legal aid. During my time, it is just an option, but now I believe it's mandated. And to do the legal aid, you would have to go to court, for some mentions or even to do some mitigation for some small petty crimes. And for that, you can call yourself doing something very noble. And as you become a lawyer later on, apart from legal aid, which you can volunteer, you can do what we call a pro bono work. Okay, pro bono work is actually to help those in need. For example, those who are poor, and but because the disputes are actually more complex, that the pupils or the students are not able to assist, then you got more senior lawyers who at least allocate some time of the year to do some pro bono work, and they would actually could be senior lawyers who would go to court and defend someone. And sometimes the pro bono work could also be defending a civil action where you feel that the aggressor, the plaintiffs, are filing a frivolous suit just to oppress the poor, or just to oppress those that they feel that they cannot afford legal assistance. So those are the times where you can actually help, others, when you go to court, and they will be indebted to you, they'll be deeply indebted to you. But I want to share one of my experiences when I was doing my chambering 20 over years ago, when in fact, it was during my first few months of chambering. I was so new, just came back from the UK after my bar school. So obviously, just to tell you, after your bar school, when you come back, you start your pupillage, you don't know much. You are so green, you are so inexperienced. So in the eyes of lawyers, we know nothing. We are inexperienced and so on. But because I have my own chambering mates, we call it, chambering, pupillage, whatever we call it. But actually, the right word is actually chambering in Malaysia. Pupillage is generally in the UK. One of my chambering mates, in my firm, was stuck in his hometown, and he was supposed to go and do legal aid, in court. And he actually called me up in the morning and asked me if I'm properly attired, in my suit, in my white shirt, so I can go to court at 9 o'clock because we start work at 8:30. So I said, yeah, why so last minute? He said, oh, nothing. He said, just go and get another date. Then I said, okay. Then I just took a piece of paper, and then I took a bus, and then I reached the court last time in, the Padang there, Sultan Abdul Samad, is it Sultan Abdul Samad? The building, in Padang, now it's like a museum or something. So that was my first experience going to court just to get another date. So when I arrived there, I got panicked. You know why? Because I found out from the interpreter in court that it was fixed for sentencing. So my friend actually got confused from the legal aid center that it was fixed for mention where they're supposed to get another date to get a senior lawyer to attend to do the mitigation. So I ended up being the lawyer who's supposed to, actually I was pupil maybe in my first month or something like that, to do a mitigation. Can you imagine that? And a mitigation before sentencing. So the person has already been found guilty, and generally pupils don't do that. And then at my level, I wouldn't know how to adjourn the sentencing or adjourn the mitigation and say that I'm not competent enough to do it or something like that. But to my shock, the magistrate then, while it was it was a theft, some petty crime, but to my shock, the magistrate was quite a bully. First of all, she refused to guide, though she knew that I was a pupil, and she refused to adjourn the session. And I still remember I was so traumatized because the whole family of the accused was in court. And they can't speak Bahasa, neither can they speak English. They are a Chinese family. And one of their sons is being charged and found guilty, and it's a day of sentencing. And when I met the family in court, I was so shocked because I still remember the mother knelt before me. You know, there I was like 22 years old. You know, I just started my chambering after my bar school. And you got an old lady knelt before me, say that, please help my son. You know, Chinese New Year is coming. I don't want him to be in jail, you know, something to that effect. And she passed to me a few medical reports, you know, from some hospitals to say that the son is a little bit disabled, and you know, he maybe didn't know what he did when he stole some things, you know, a motorbike or something like that. Can't really recall. And I just took the reports, the medical reports, and I thought, you know, being someone who's trying to help a friend who was stuck in Penang, and told me just to get a date so that they will engage a lawyer from the Legal Aid Bureau. Was it Legal Aid Bureau or Legal Counsel's Legal Aid? I ended up having to force to do a mitigation. And you've got the whole family placing their trust on my shoulders. And mind you, I was 22 years old only that time, and without any experience. So armed with the report, I thought I was very clever. So I went into the court again after the after it was stood down. So when it was recalled, the accused was inside the, what we call the kandang, we call it a kandang, there's a space for the accused. And the court said, okay, I think he or she spoke in Malay, the magistrate, saying that, you know, what mitigation do you have? So being a young pupil without any experience, I just said that, oh, Tuan or Puan at that time, I said, I have some reports here to say that he shouldn't be jailed, you know, because he's just incapacitated, you know, he's actually mentally handicapped. So I handed over to the interpreter and then to the court. And to my shock, guess what? The magistrate went to sentence him, you know, to where? To Tanjung Rambutan. Then the magistrate said that, well, since you have got a defense of insanity, I think the only option that we have is to send him for an observation in Tanjung Rambutan. So they actually handcuffed him, you know, they handcuffed him in court and then brought him to the remand place behind the court. And then the whole family cried, you know, because the whole idea was actually to get him out for Chinese New Year. Then you got an inexperienced pupil who doesn't know what to do. And when given this sort of evidence, I'll just produce the evidence without knowing what could be the consequences. Then it ended up causing someone to go to Tanjung Rambutan for Chinese New Year. And up until today, I was still in utter shock because at that time we don't have handphone yet, by the way. So I couldn't call anyone. I could only get back to my office and then using my office phone to call my friend who is back in Penang to tell him what happened. Then he was also shocked. He said that, so how, you know, we need to pass it back to the Legal Aid Center, you know, to get a senior lawyer to undo what you have done and so on and so forth. So basically my experience tells you that, you know, we as lawyers or lawyers to be like, you know, or even pupils, sometimes for us to know what to do is very important because it may not be life and death, but it's between spending time at home or in Tanjung Rambutan during Chinese New Year. Because of my inexperience and really do not know what to do. And during those times, 20 years ago, there was no handphone. Once you're in court, that means you're in court. You can't tell the court, especially when you're so young, you can't say, stop, let me go to the phone booth and go and make a phone call. The magistrate will bully someone who is young and will tell you that, no, it's going to proceed. Tell me what you have and I will make a decision. So obviously something was not right during that morning, but you could see what our roles are sometimes, the ability to help others. If I was more equipped, or if I was someone who is more senior, perhaps the difference was that I could have actually gotten another day, or at least asked to post bail or something like that, just for Chinese New Year, and to have some surety and some guarantors to ensure that there's sufficient assurance that the person will come back for sentencing, and then only get a more senior lawyer to do a real mitigation. Perhaps he could even be a first-time offender. There is no jail sentence. It's just perhaps a fine or a warning. But ended up, because of my inexperience, by showing the medical report, he ended up landed in Tanjung Rambutan. Can you imagine? It may be for a short term, but at least over the period of Chinese, that was like a few days before Chinese New Year. Then he got into that kind of trouble. So I got so traumatized. But I did tell myself that, how important lawyers are, because be it fee charging work or even pro bono work, when we do a legal aid, when we assist legal aid, we can help others, for their liberty, for them to get released, or if they're charged, especially when they can't afford, obviously, if I remember correctly, this individual came from a very poor family. That's why the whole family was there. They can't afford legal fees. That's why they approached the legal aid center. So so that's my experience. That's my personal experience. And in the years to come, if you become a lawyer, I do encourage you all to do some pro bono work, okay? Especially if you are in a larger firm where the partners actually allow you all to spend a little bit of time to do pro bono work to help, like, single moms, to help rape victims, for example, to help prostitutes, or those who are being charged, or some of the drug addicts, not by choice, the abandoned children and all those. You can, because sometimes when they are charged in court, without pro bono help, really they'll just land themselves in jail, or they land themselves in like Tanjung Rambutan or some rehab center, which is really nasty ones and all. So we do have the ability, and we should take advantage of our position in your years to come when you become a lawyer, to actually help others. Okay, then the next one, litigators are also another special breed that, apart from the members of parliament, our state representatives, the Adun, or our MPs in parliament, where they actually debate on laws. They propose, the government proposed, and then the MPs will debate, and then they vote upon it, and then they create new laws. They make changes of laws. The other category, if you've studied your first year, you've studied what English legal system, if you're from the UK law school, or your Malaysian legal system. We as lawyers will also be part of lawmaking process, because when we argue a case, we create judicial precedence. So when you study your ELS, your English legal system, or you're a Malaysian law student, you study about the Malaysian law system, you only have two types of law. One is statute law. Statute law is actually created in parliament, where our representatives, someone that we go undi election, we vote them to the parliament, and they will engage all the experts to advise them, and then they will propose some laws, and they will debate about it, and they will vote on passing the laws. They create laws, and some existing laws, they will also create amendments to it, as proposed. They will send it to the AG's chambers, and so it's a long process as they create laws. But not forgetting, the other half of the laws are judicial precedents. And these laws are generally created by litigation lawyers, because when we go to court, when we argue and try to interpret the statutes, we interpret the legislations in court, and we bring it up all the way to federal court. And when the federal court agrees with every day as well. As they are created in the parliament, they're also created in either court of appeal or federal court, or if they are not appeal, even in high court, new laws are created every single day. When we argue before, when we put in efforts to do our research, research on the UK law, the Australian law, the Singapore law, and all our local laws. You heard of your MLJs and the CLJs or whatever, the LexisNexis. We do all the research and we apply those laws to argue before the court, to argue and interpret some statutes. And once the court agrees with us, and then there's a written judgment or they're reported in MLJ themselves and all, these are new laws. So apart from statutes, we are also lawmakers. While we don't call ourselves lawmakers, but litigation lawyers together with the judges, we are lawmakers. Or at least we facilitate the judge to make new laws as they create judicial precedence. So you can imagine how important a litigator is. It can be between, like for example, you create new criminal laws, is between what is fair and what is not fair, between life and death, between how what you do, will determine the future of the country, because we set forth what is to be followed by our predecessors, or other lawyers who would use our case precedent, as we argue, to create or strengthen, to enhance the law. So it is actually quite a high call for litigators to actually be equipped, to be fully researched and do their work properly, so that they can actually create laws together with the judges. And of course, there are some other points that I've actually considered, like unlike other areas of law, I believe as a litigator, there are more mental stimulation because we are always in a battle. We need to prepare ourselves. We need to do a lot of research. We need to do cross-jurisdictional research. We need to convince ourselves, and we need to apply the law into the factual metrics in order to convince someone who is another intellectual, a judge. So it's actually an intellectual challenge. It's like you coming up with something to battle against another intellect who is a fellow lawyer. We call them our learned friends. And then we go before the court, appear before sometimes 1, sometimes 3, and in federal court 5 learned judges. And when we deliberate and then we argue and when we try to convince and persuade, so that ultimately a finding would be something that we have all researched and be convinced that this should be made law. And this obviously involves a lot of mental stimulation and a lot of intellectual challenge, because we will try and outdo each other, of course, gentlemanly, outdo each other intellectually. And in this type of practice, I cannot imagine any other areas would have such practice. For example, you do corporate. Well, corporate, you need to be very intellectual as well, but you don't keep on challenging someone in a corporate meeting on your feet that goes on for hours. You don't do that. If you're not happy, you go back, or perhaps you discuss with your clients and you strategize and all those things. I'm not saying that there's no intellectual challenge, but in court, you have to do a lot of things off the cuff, and you have to be always on your feet because you need to answer 5 judges. You have to counter arguments from your opponent, and you should be able to read new laws that are being presented to you by your opponent, sometimes by surprise. Sometimes I'm saying that because you're supposed to serve all these things in advance, and issues and arguments raised by the other side, you have to file your rebuttal. You have to argue your rebuttal on your feet. That means while standing up, you have to do all these things. So it helps stimulate your mind. And because of that, of course, later I'll talk about the 5th point, is that it's a lifelong career. Perhaps because we argue so much, of course, there's the other side of the coin. We argue so much, we have a shortened life because, our high blood pressure is there, because we're always arguing. Can you imagine if you reach a certain age, or at least your parents, if you ask them, if they are in the business of always arguing, obviously the high blood pressure is very high. the risk of heart attack and stroke is always there, especially for litigation lawyers, because we need to stimulate our minds so much, and we need to challenge each other, we need to defend ourselves, and so on and so forth. We need to be upright in the position that we take, and we need to compromise if it is necessary in order to get the best results for our clients. So all these things actually adds up to the stress. But on the other side of the scale, by such mental stimulation, perhaps you will not get Alzheimer's, you won't get dementia. Why? Because we think too much. Litigators think the most compared to any other profession or any other areas of practice for lawyers. Because we think too much, when we are old, even if you go to court, I have faced an opponent who is 80 over years old. At that time, I was in my 20s. I still remember I was in Ipoh. So I've got one of the most senior lawyer in Ipoh as my opponent as I was representing the bank. He was acting for an individual. He was like 82 or 84, I can't remember. And I was like 24 or something like that. So I can be his grand or great-grandchildren, a great-grandchild. And after court, we even have coffee, and I went to his office and visited his office and so on and so forth. So litigators generally, they would have a lifelong career, because as you grow more senior, you become a true senior counsel where you will be working with your solicitors, almost like the UK scenario. Solicitors, barristers. Because the senior counsel in Malaysia would generally just do counsel work. That means the paperwork will be done by the solicitors, preparation will be done by your assistants or some of the junior partners and so on and so forth. So even if you reach 70 or 80 years old, you can still go to court. As long as your mind is still sharp, even if you can't really see properly, you take time to actually go through the documents if you can, and go through the law, which of course I expect when you're at that age, most of it is already inside your brains, and you can still continue arguing or present your case. I think I shouldn't use arguing when you're at that stage. You can continue to do your submission, you can continue to do your persuasion in court and still earn a living. And in Malaysia, the surprising thing is that the older you get, generally your fees are actually very high as well. As you reach the senior counsel stage, you can demand really huge fees. When you step out and into the court and argue a case as a senior counsel on behalf of your clients, you really charge a premium. So it's a lifelong career. And one very important fact is that, again, this is my own personal experience, and I believe many will agree with me. When I first started practice, it was in the mid-90s, in the mid-90s, which is 20 years ago. We had our Asian financial crisis in 98. That was shortly after I started practice. And at that time, there was only one area that survived the recession then, the Asian financial crisis. That is litigation. Other areas, I still believe, but the firm that I was chambering and, when I first 2 years of my practice, they were experiencing shortage in work for conveyancing, because recession, nobody builds house, nobody sells house, and most importantly, nobody buys house. So if you're doing conveyancing, it will be maybe almost zero, throughout the year. And if let's say you've engaged many conveyancing lawyers, they'll be out of job. They need to retrain themselves. And for that matter, corporate lawyers, unless you do some insolvency work, if you do like corporate restructuring work, okay, perhaps. But if you do like corporate finance, nobody will go for a listing in Bursa. Nobody go for public listing, during a recession, or nobody will acquire land and to do a major sort of development and so on. So even the corporate lawyers are also stuck. And of course, some other areas like IP, aviation, competition, and so on and so forth, they too will also be stuck, during a recession, especially. And I experienced it again during the last 2 years over the COVID-19 pandemic in the year 2020, 2021. And we realized that only litigation will strive. And litigation is the area that instead of the rest going down during recession, litigators are the ones who do even better than during normal times. So it is something to ponder about, because back to 1998, that time when I first started practice not too long ago, I still remember I had some colleagues then who were my junior. They just finished a chambering in 1997 and 1998. I done mine in 95 and 96. So 97 is where Asian financial crisis started. So they finished theirs was in 1996 and 1997. Then, as usual, some of the pupils, after they finish the chambering, they actually go for a long break. You know, they go to UK, you know, to take a break before they start to practice as a lawyer. And some of them were actually retained in the corporate and commercial department or the conveyancing department. And of course, there are those who are retained as in the litigation department. But when the Asian financial crisis hit, those in the corporate, commercial, and conveyancing department, their offers to be a lawyer in a firm was actually revoked. You know, either way, because they knew that there won't be any work. So they lost their associates' positions in the firm, and only those who were offered to be a litigation lawyer got their places, because at that time that firm does a lot of banking, debt collection, you know, foreclosure, bankruptcy. So it was a time where there was a spike in work. So it was good for those who are doing banking litigation. So at that time, I told myself, I was in my second year or something like that. I told myself that, well, thank goodness I chose the right area to practice, because I realized that litigation is the only recession-proof area of law that I can be so sure that whether it's good times or bad times, there will be work, and I'm still wanted, you know, by my firm at that time. But of course, fast forward 25, 26 years later, you know, here I am now as a senior partner of my firm. Litigation indeed is actually recession-proof. You know, when we face some difficulties in some other areas, but as far as litigation is concerned, the deeper we are in recession, deeper the recession is, the better we'll perform, because there'll be more disputes. And of course, apart from litigation, I do employment disputes as well. And as you know, during a recession, there'll be more employment disputes. There'll be loads of restructuring, retrenchment, you know, a lot of dismissal exercises. And then we have to go to court to defend the company for wrongful dismissal and so on. And there are more disputes. When recession comes, you know, people are not happy with one another. They breach their contract and they couldn't pay. So there'll be a lot of debt collection, and then there'll be a lot of insolvency. Companies are being wound up, people are being made bankrupt. There are more such disputes. And even family disputes. There are more disputes when times are bad, especially as a family company, you know. One is out to cheat another, you know, there's fraud involved, there's conspiracy involved, there is breach of some of their obligations in the contract and so on. So it is only during these times we are overloaded with disputes. So I realized that it is not just recession proof, it is actually recession positive. So when it is recession, we do even better. So there's even a saying for some of this, those that does restructuring and insolvency work, they say that, well, the economy is not bad enough. We need another 2 years of you know, lockdown perhaps, until everything collapses. That's when we come in, because there are lots of restructuring work, there's a lot of insolvency work, we do a lot of judicial management, and then you know, do all the restraining orders in court. So the litigation lawyers, we look forward to recessions. It doesn't affect us, and in fact, we do much, much better during recession. So that is again something which is very different and contrary to other areas of law. Other areas of law, you need a booming economy, like conveyancing, like corporate, you need a booming economy. But for litigation, we want recession, but during good times, there are also a lot of disputes. You know, human beings are imperfect. Whether it's good or bad times, there will be crooks around. People who do not, honor their contracts, who try to cheat, or even employees who try to cheat the companies, trying to have what you call kickbacks, if they're in position, including directors, including managing directors. So we have lots of such disputes. We have to injunct them, as they join another company. We have to sue the other company for conspiracy to defraud, conspiracy to injure, and so on. So there are multitudes of claims, during good times as well as bad times. So in summary, like I said, if you want to move into becoming a litigator, there's an opportunity for you to help others, especially when you do pro bono work, and you will feel important because you are also like a member of parliament. You create new laws as you assist the judge by presenting new cases, distinguishing cases of the existing law in order to create new laws. So we are actually lawmakers as well. And it is a profession where we think the most. We have a lot of mental stimulation on a daily basis. And we have job security because it's recession proof. In fact, it's recession positive. And because of the mental stimulation that we have as litigator, we should have a lifelong career. And again, counter other practice areas. In other practice area, this is again my personal view. Let's say if you are doing conveyancing or you're doing corporate, as you grow a little bit older, I could sense that even the younger lawyers would have an upper hand because perhaps based on pricing and based on aggressiveness. And I hardly see a corporate lawyer who are in their 60s and 70s, or for that matter, even 80s, never ever, because they probably retire in their 50s or 60s. And as they grow older, corporate deals may require people who are more dynamic or younger. Whereas this could be just in Malaysia, but I can't speak on other jurisdictions because I'm not too sure about that. But as far as Malaysia is concerned, the litigators who are earning the biggest bucks in Malaysia are the old ones. Okay, they could be in their 60s, 70s, and many of them are in their 70s. And these are the senior counsel. It's the only area of law that you could still command as a someone that could charge the highest in that area when you're in your 70s. Can you imagine? I still remember speaking to one very senior counsel who was also an arbitrator, and he was shocked to find out, because he was a retired judge. He was on the federal court. So I was having a discussion with him after our arbitration, and he told me he was shocked that in Malaysia, after he retired as a federal court judge, then he moved to become an arbitrator. He found out that how much all these senior lawyers earn and how much a senior arbitrator earns. He was so shocked, and he can't believe himself. After he retired, that was after I think the first 5 years of his retirement, and we had this conversation, and he wasn't too sure whether this is the same in the UK or even in Hong Kong. But it's good news, if you practice in Malaysia, if you establish yourself as a well-known litigator, your price can only get higher generally if you keep up with the times and you do better as you grow older. And there is deference, when you appear in court, when not just your peers, your juniors are judges. When you're in your 60s and 70s, generally your juniors, it could even be your pupils who are the judges. So you appear before your pupils. Can you imagine just the perception that people have, although it should not be, but the perception that clients have that you appear before your pupil, they're willing to pay you top dollar because they realize that you may get the deference in court. So that is the difference for litigators. That means we don't have to retire. We can actually practice and charge high fees until the day we basically collapse. Okay? Unlike any other areas where their career is actually a shorter span. Litigators don't have to retire, so we have a lifelong career. And that, to me, I don't think anyone has spoken about this before, but this is from my own research and my own experience that I realized that only litigation we have a lifelong career. Because I personally have faced many lawyers in their 70s, or for that matter, that Ipoh lawyer who was in his 80s. And all the senior counsel, I don't want to name names, but the senior counsel that we read in the newspapers, they are mostly in their 70s, 60s and 70s. All the Tan Sri and the Dato Sri senior counsels, they're all in their late 60s and 70s. So they are continuing their practice and they are thriving. They're doing really well, at their old age. Okay, that is some of the really plus points as a litigator. And now I'll go into what it takes to be a litigator. Okay. Okay. First of all, we need to be very creative, and we need attention to detail. As a litigator, you can't you can't be very careless. You cannot miss out on details, because when you go before the court, the judge expects you to be perfect. And if the judge make a wrong judgment as a result of the lawyers, then it is the lawyer's fault. As an officer of a court, we need to ensure that we give the right details, right evidence, and point the judges to the right direction, because we are in a adversarial system. We are not inquisitorial system. So in a Commonwealth jurisdiction, we're in an adversarial jurisdiction where the judges are only to determine the law based on what are being presented by counsels, by lawyers, by litigation lawyers. So we have a duty to ensure that what is presented, including the law, is the right law, so that we won't mislead the court, which is the contempt. We don't do that. So in an inquisitorial civil law jurisdiction, the judges can actually inquire into it. The judges are the ones who would also do the research. There's no judicial precedent, in a civil law jurisdiction. But in Commonwealth jurisdiction, the lawyers play a more important role. That's why I said that we can call ourselves, litigators can call ourselves lawmakers. In a civil law jurisdiction, the judges are more the lawmakers. But here, if we don't feed the judge do not have anything. So the judge will have to depend on the lawyers. That's why we have to be very detailed in terms of facts finding, factual metrics, evidence, and application of the law to the presented facts before the judge. So we have a duty to ensure that everything is the truth, nothing but the truth, and also including the law. And we have to be very creative to create new laws. If we only argue what is in the past, either we'll lose the case or we won't create new laws, because we're just citing judicial precedent. There are sometimes things that have not been argued by our learned friends, not argued by other lawyers. We get inspiration from Hong Kong jurisdiction, sometimes even US jurisdiction, and most importantly, the UK jurisdiction when we read the All England report and so on and so forth. And we get inspiration, and even in Companies Act or in criminal law, sometimes we look at the Indian jurisdiction, the Indian law. So armed with all this different jurisdiction, we can be creative so that the judge can be convinced that, perhaps there's an extension of this part and area of the law that we could create. And once I set it as a judgment, then in future, because we're in a common law jurisdiction with a judicial precedent, there's a binding judicial precedent, then the subsequent lawyers will have to use your case to argue until they become creative, or even more creative than you, to create new laws and new laws and new laws. So you need to be someone who is very creative and someone who is very thorough, someone who is into details, someone who will read everything. And that's what it takes to excel as a litigator. Okay, then the next one, I talk about persuasiveness and the ability to communicate excellently. Persuasiveness, I think, is actually quite obvious. We need to persuade the judge. Okay, and communication is also very important. In order to persuade, we need to be very clear and distinct in what we communicate with the judges. And sometimes it's also very important to communicate with our opponents so that they know, what position we are actually taking. And I cannot rule out the importance of, or cannot really underemphasize the fact that we need to communicate with our clients very well, so that we know their instructions, and we know we won't argue something or understand the factual metrics differently, because we have to depend on what our clients actually instruct us or tell us the story, and we need to sometimes, or if not most of the time, verify whatever they tell us by showing documents, or if not, we may even need to make a site visit and all those things in order to understand the whole scenario and to basically test the evidence. So communication is actually very important. Actually, that leads us up to being very analytical and research. Of course, as you grow older, and you run a large firm, you have research assistants, and sometimes you have librarians. We can hire someone, a knowledge manager who does just the research, and then we have our pupils, we have our junior lawyers, we have a senior lawyers, we have a junior partner. Because so many people trying to do all the research to group and collate all the case laws around the world, so that the senior counsel could actually sit down and take out what is not relevant and put in and compile those that are relevant, in order for us to communicate with our clients, to advise them this is the position you should be taking, and ultimately to persuade the judges to go with the position that you have advised your clients to take. So we have to be very analytical, and our research skills, especially when you're a junior lawyer, has to be really excellent. You cannot miss things out now, basically, because again, from my experience, I've got this experience. I still remember this judge is no longer around now. There was one time, no longer around, as he already passed away. In fact, when I was a junior lawyer at the time, most of the judges that I appeared before, many of them already passed away already. Since I've been in practice for, since 1996, for over 25 years, more than 25 years in practice. So, when I was 20 plus, let's say they're 50, 60, yeah, they will be in the 80s or 90s if they're still alive. So some of these judges, I still remember there's one judge who actually cornered me when I cited a case from the Court of Appeal. And the judge cornered me and recorded how he actually posed such questions to me, as he cornered me by asking me, when you did not cite the federal court decision, was it on purpose? I said, no. He said, but if you did not cite the federal court case in your submission, it can only be two possibilities. And he said he's going to record my answer to how I'm going to answer to his question. Could the possibility be that you wanted to mislead me? One, or you have been negligent as a lawyer. You have failed as a lawyer to know that there is a federal court decision over and above the Court of Appeal decision that you cited and argued on. So he asked me to choose. Can you imagine you got such judges? It's either you mislead the court that may lead you to a contempt of court, or you have been negligent that he's going to record so that your clients may sue you for negligence. So as a lawyer, you can face such a situation that you need to know what to answer, or what is the lesser of two evils, or whether you can be evasive when you're put into such a position, or you can challenge up, or you can stand up against the judge. That's why when they appear before the judges are way, way below their junior. So generally judges would not kind of bully them by asking them such questions, by saying that it's either you try to mislead or you're negligent. Choose one. There's no option 3. I wouldn't allow you to have an option 3. So these are the things that, just to forewarn some of y'all who want to be a litigator, you have to be very sharp in your minds, you have to be very creative, and you do not lose out in your research. That means you have to thoroughly research everything. Then the next one, you have to be assertive but not aggressive. Okay, you hear a lot of lawyers who are actually very aggressive. I'm one of those who are fairly aggressive, but it may not necessarily be the right way, because you may put the judges off, when you're too aggressive. But you need to be assertive. You need to be very firm in your position, and not because you always must be right. So even if you're wrong, you can always apologize. If you make a mistake, you could say that you apologize, and you can correct the situation. Okay, but assertiveness is actually a virtue, if you want to become a litigator. And I on the next point, I talk about being a competitive spirit. Of course, litigators generally, because we are fighters, we have to be competitive. We are like sportsmen. I always sometimes give example that we as lawyers, we are like when we go to court, we are like in the boxing ring in a heavyweight match, or nowadays MMA is even more popular. MMA, you are in the final of MMA for the world championship belt. So when we go to court, though you may have, when you're a senior lawyer, you have a lot of assistants with you. Sometimes I go to court with 5 assistants, and then my opponent will have also 3, 4, 5 assistants. So when we go to court, we have to be very competitive, because we are out to do a job. It's like a battle. Our clients are sitting behind at the gallery. They will see how we battle, because some of them, their company is at stake. Some of them, their family is at stake. Some of them, their life is at stake. Some of them is relationship and deals are at stake. And some of them are in the billions of dollars. So they are actually sitting at a gallery, and they expect the counsel to be competitive, to be competitive enough to fight for their rights, to fight for what is right, and to ensure that nothing is left unargued. So whatever that needs to be argued, it has to be presented. Whatever needs to be submitted, it has to be submitted. So this is how we learn to be competitive, like as if we are in a boxing or an MMA ring, and some of our opponents are really competitive. So if you are less competitive, it will be very clear. It's just like a boxing match when you face a real champion or an MMA. Before you know it, it's a knockout already. People will knock you out if you're not ready, you're not on your feet, if your mind is not sharp enough, or you're not basically clever enough on your feet. You will lose because you're not competitive enough. And your clients knew it, and before you know it, they'll run away, because they know that my lawyers are not good enough, they're not sharp enough, they're not intelligent. You need to have. And last but not least, of course, resilience and grit. This is very important, because a lot of lawyers actually give up, as a litigator, because it's tough. When you first started, you're like a nobody. You get bullied by the magistrate, you get bullied by the registrar as your pupil. They really bully you. They strike out your cases for no good reasons, and you have to reinstate it. You get scolded by your partners and all. You need grit, because if you're willing to work hard and you're intelligent and you're going to put in your hours, you need to have grit to know that you have a long-term goal to be a senior counsel, to be a respectable counsel. Then only you can succeed. You don't give up, not halfway through, I want to go to practice in-house and so on, because I gave up, because it's just too tough. I'm just a nobody, I can't establish myself, and then I'm just earning like 3,000-4,000 ringgit. It's like, where am I living? I can't even earn enough to pay off my loans, from my law school or something like that. But be rest assured, if you have the grit, if you're determined enough, you will succeed one day if you choose to be a litigator and be a good litigator. But there is no shortcut. Hard work. During my time, there's no internet. We have to spend a lot of time in the library, like the one my back screen. By the way, this one is the Lincoln's Inn library. I love this library, and I just downloaded it this morning. It is the library that I spent a lot of time during my bar school in Lincoln's Inn, and because I didn't live in a very nice condition in London, so I find that this is a more conducive place for me to study. So I think most of the days I'm actually spent in the Lincoln's Inn library in order to pass my bar school for the very first time. And it applies to all the junior lawyers as well. Because if you want to be a good lawyer, you need to read a lot, you need to analyze a lot, and you want to be a senior counsel one day, of course, you have to start to be a junior counsel in the first place. Be respectable, be helpful, help your senior counsel, not to be calculative, don't look at money all the time, then you'll be able to succeed. Okay, that will somewhat end my so-called presentation. Before we go to Q&A, how long have I taken, Yvonne? Too long?
No, it's actually less than 1.5 hours.
That's good. So at least there are some time. We can. Okay. So now perhaps what's next? Do you want a Q&A, or you want to start, or you want to?
Yeah, perhaps like after your presentation, we can proceed to a Q&A session, so that the floor is open to all the participants to ask like any questions related to Mr. Leonard. Since we have like some extra time, so like feel free to unmute yourself and
unmute yourself and then on your camera lah. Don't be shy. If you don't on your camera, I feel very lonely because well, there are 80 over of you all, but then what I can see is just a few only. Okay, anyone?
Someone in the chat box who say she would like to record, but as she'll be using the slide for her reference, so maybe Mr. Leonard, you can email me the slide so that I can circulate it to the participants.
Okay, sure. So any questions? You can ask me anything lah. Basically, there's no silly question or something which is like stupid questions, as some people call it. There's no such thing lah. Today is a Saturday, and it's supposed to be casual, and I'm actually wearing a shorts. So just any silly questions you can come out with lah. Generally, you don't get many of such opportunities over the weekend talking about your career and so on and so forth. But it's very important to know this. I wish when I was studying law, I had such an opportunity to talk to people about what areas. While I have no regrets because I think I made the right decision to be a litigator, but it may or may not be a field that is suitable for you. So I think it's important that if you've got any question, you just ask. Don't be shy lah. Oh, someone put up a hand. In fact, if you want to be so shy, how can you do advocacy next time? I think the following weeks you're talking about advocacy training. When you want to do mooting, you want to do advocacy, you want to do litigation, you need to have thick skin. It's like we are in a public. We appear in open court, and sometimes when in federal court there are another 20, 30 lawyers and another 20 outsiders. So we are up on our feet, and sometimes we get scolded by the judges and so on. And if you don't have thick skin, I don't think you can last. So we need a thick skin. Don't be shy. If you have something, you just ask. Like I said, there's no such thing as silly questions or anything, because every question you can see it in many ways. So it can't be a silly question.
So if I may ask,
Sure.
You mentioned about how the senior lawyers actually earn more and so on, and there's no actually retirement age, right? So there's a question that popped in my mind is that what do you think as young lawyers, right? Do you think it is harder for young lawyers to establish themselves and to get cases when there are these senior counsels that are, pushing 80 and so on, having, being popular and so on, where people rather go to them compared to us? Like, do you think it will be a challenge for young lawyers to overcome?
Actually, this one is a very smart question. You know what she's thinking about? She's thinking that since it is a lifelong career for those fellas who are like so established, so wouldn't the cake be too small for everyone to share? Because since the old lawyers, they just don't retire. They work until the day they kick the bucket. So where do we stand? Okay, my answer to you is this. You can just imagine, I can just assure you, there's actually too much work there are too much work to be shared around. Okay, if you are junior, obviously you don't do the big cases, because there is no way a client would part a few $1,000,000 to engage you when you are junior to do something which are so complex that are beyond you. But before you reach that stage, there are certain work the senior lawyers would never touch. For example, debt collection. When you're junior, you do banking work, for example. You act for the bank, you chase after credit cards. Those people who defaulted in a credit card. You think a Tan Sri, Dato Sri lawyer would do such a thing? Obviously, they're not going to do it. They will act for some politician. They will act for some big disputes, or some of the arbitration lawyers will go for those oil and gas, big disputes, infrastructure disputes. Those are the things that junior is beyond. Could be as much as what you see behind in my virtual background. Tons and vast loads of documents. And it's beyond junior lawyers. You need a big team, you need someone who is very intellectual, and you need experience in order to reach that stage. So I wouldn't be envious of those people who are earning. Okay, there's some rumor that there are some lawyers who would actually get $1 million, $1 million ringgit each time they appear in the court. That means every appearance is at least ringgit Malaysia 1 million. And I'm not envious of such lawyers, because these lawyers would have earned their keeps over the last 40 years, 30 to 40 years. They really worked hard. They really have done so much research as they were junior. They would have established themselves. They would have, gather himself so many great and multitude of clients and so on. They actually deserve it. But when you want to start somewhere, there is enough work for you. When I first started, I was doing that collection. Then I move on to do some contract, breach of contract. Then I move on to do some defamation work. Then I move on, subsequently, as I get more senior, I do some dispute, shareholders disputes, oppression work and all those things. Then I got even more senior, I do more complex work, I do breach of trust work, I do knowing assistance, knowing receipt work, I do conspiracy to defraud work, conspiracy to injure work. And then I do more complex shareholders disputes. And then I do construction disputes. And I do arbitration. Then I do international arbitration. I do satellite disputes. So as you grow more senior, somehow you're able to attract different types of clients, different types of disputes, different types of work. But when you're junior, these are the work that the senior lawyers would not want to touch. You know why? Because the clients would never be able to afford the fees of a senior lawyer. Because like I mentioned, I'm not in that category yet. Hopefully one day. But those who reach a stage where every time they go to court, they earn $1 million, do you think when you've got a 5,000 debt, you can afford those type of lawyers? Obviously not, right? If someone owes you 5,000, who do you go to? Of course, a neighborhood lawyer. So it's the same thing. You think about a doctor. When you have a fever, so slightly, or you think that you may have COVID positive, okay? Slightly, you need to do your PCR test or something. You don't go call around to go and look for a cardio surgeon, or you want to go for a brain surgeon, or you go to the most well-known eye surgeon or something like that, or for that matter, someone who is well-known Dato Sri surgeon or something, just to look for a tiny fever. Am I right? You don't, right? Because you know where to look to. You go to your neighborhood GP, a general practitioner. So the same thing. If you want to buy a house, you go to a small firm, conveyancing firm. When someone owes you 5,000, 10,000, 100,000, you go to a smaller firm, medium-sized firm. Only when multinationals or PLCs, when they got bigger disputes and they got a bigger budget and the board of directors approves a bigger budget, then you go to the more expensive lawyers, someone who has got the reputation to do complex work. So while in Malaysia, we may not have barristers and solicitors like how I explain it, like in the UK, Hong Kong, and Australia. But in Malaysia, we do have senior counsel, and we do have a specialized litigator that only does very complex cases. So they are equivalent to the senior counsels or even the Queen's Counsel in the UK. And in fact, Malaysian senior counsel, actually, they dare charge even higher than the Queen's Counsel in the UK, for some of the large disputes. So what I'm trying to say is that there is never out of job for lawyers, especially litigation lawyers, because there are, in a day, perhaps every day, there are tens of thousands and hundreds of thousands of new disputes that the clients or potential clients that require the assistance of lawyers at all levels. So to your question, it's a very smart question in a sense that you are even thinking about the future. And what I say is that for other practice of area of law, the lifespan is shorter. For litigator, the lifespan is bigger. But the only difference is that for litigator, while the lifespan is longer, there's always more work for litigation compared to other areas of law, because litigation is recession proof and recession positive. Whether good times, bad times, when there's human being, there's no perfection, there is dispute. Because human beings, we are not perfect. That's why there is dispute. Okay. Other question? It's a very good question. Any other questions?
I think Noor Adini raised her hand, and then followed by Rakesh and Adriana.
Yes, Mr. Leonard.
Yeah, sure. Hi, Noor.
My name is Adini.
Yeah.
So if I want to become a litigator, what is the first step that I should do from now on, to become a litigator once I finish my law school?
Okay, I'm quite unconventional. If you speak to some idealistic lawyer, they may tell you something else. Okay, I'm very unconventional. I'm going to tell you, when you're in law school, choose the subjects that you think you're going to do well, and try to get a first-class honors. That will be a good platform. I'm never a believer of choose the subjects that you like, but it's very tough. But I like it. Of course, the core subjects, you have to take it, but all the other optional ones, choose the one that you think you can get first class. So you get your first class. For those who are going to, you can get your first class, get the first class honors, then get yourself in a very good and competitive firm. Because if you don't get good grades, trust me, it's getting competitive now. There are a lot of law graduates after the CLP who are currently still jobless, to tell you honestly. And my firm receives many applicants on a daily basis, and we just can't take them because vacancies are just full. So in order to differentiate someone at that level of recruitment, you don't have any experience. Mooting doesn't count. Seminars doesn't count. We look at grades. So have good grades. So what I encourage is that try and focus to get good grades. And for many people, in order to get good grades, they have to be very careful in choosing the subjects that they actually can do well. Like I said, you may listen to some others say that just do whatever you like, but then you choose the subjects which you like, but you can't do well, you may get a third class or a second lower. Then I can tell you it's going to be very tough later on, because from the perspective of an employer, we receive even many applicants who has got first class. If you've got many applicants with first class from the UK, what are the chances that we'll even consider 2-1, 2-2, or even third class? You know what I mean? So even if you don't consider first class, we at least go for a high 2-1s. So get good grades. Especially if your university is not the Oxbridge or the top London universities, then try to get as good grades as possible. Because when you go out in a job market, it's going to be very competitive. And for those who wish to even have some experience working overseas, like in Singapore, in Hong Kong, they place grades much more important than Malaysia. So get good grades. I'm just being very practical here because I'm an employer. Yeah.
Thank you so much.
Sure. A few people raised their hands. Maybe the moderator can choose.
Perhaps we can have Ami. We'll deal with the questions in the chat box, and then we proceed with Adriana and Irene.
All right. Hi, sir. Okay.
Hi.
My question, as a practicing lawyer, you did tons of research before you go into the court, right? And then you emphasize so much for the junior lawyers or future lawyers to do thorough research.
Yes.
So what are the platforms for us to do research other than, because as a student, I relied so much on LexisNexis, and then other than reading precedents, past cases, and also journals if included. What are the other platforms that we can use? And also I want to know, to what extent do a lawyer need to do research in order to be called as fully prepared before they go into the court?
Okay, I think research is actually very important. Of course, now the research platform for lawyers and the students are no different, apart from the fact that we have a lot of practitioners manual as well, because in our library, in fact, a lot of firms are actually downsizing the library because we are moving online. So a lot of this, like LexisNexis, a lot of this online research platforms, they're actually just as good. The only thing they do not have is actually some of the practitioners manual, some of the UK tax, practitioners manual, let's say for construction, practitioners manual for defamation, for damages, and so on and so forth. These books you need to get updated as well, because in order, like I said, as lawyers, for us to create laws, we need to know what's happening in the UK as well, or what is happening in India as well, so that we can have a good session of deliberation before the court, as we present them with some of the arguments by these practitioners, this very well-known authors of this practitioners manual, and also case laws in such jurisdiction. But as you mentioned, you're already doing research using LexisNexis and so on. They're actually good enough in terms of all the Commonwealth jurisdiction. And I think there's is it Next Law or whatever, where we could also access the non-Commonwealth jurisdiction. Sometimes we also cited, let's say, cases from the US and so on, and cases from France, especially sometimes we do the competition cases. We have the EU cases. Sometimes we have to subscribe to a special competition law reports, where we have the EU cases in Belgium, in France, in Germany, where they are not found in the LexisNexis. So depending on the practice area, you may require more access to more online platforms. But the future is moving towards online platform. My firm used to have quite a big library, but now we are downsizing the library because we realize that not many people, like what I used to, my background in law, we don't have such a big library that you need to go to. Last time when I was practicing that time, we require big libraries. In fact, I go to UM libraries quite often last time, University of Malaysia's library, because my firm's library, of course, is not as equipped as the UM's library. And when I was chambering that time, internet is not being used. There's no such internet platform and so on. So we are still using physical law reports. We still have to go to libraries such as the one behind here and we take the All England reports, the MLJs, and we go and make photocopies at a photocopy machine and so on. So life has been a lot tougher then, but that teaches us to have grit. That teaches us to have resilience. Those teaches us, to me, to have better training then. But I may be wrong now, because I do not belong to the generation where everything is online. Although I try to keep up with times, but I think you guys should be better, in terms of doing research online. But I believe my junior lawyers and my pupils, they are all online already. So it makes no difference to me, save for the specific substantial law practice, where you require a separate paid subscription to certain reports. Most of the time, I think if you just do a normal practice, LexisNexis should be sufficient. Save for some firms, only the larger firms would have a library. All the small firms, for example, 10 lawyers and below, those sort of firms, chances are that they do not have a library unless they are litigation based or they were an offshoot from a very established litigation firm. Most of them don't invest in a library. They just go online now, especially if they are the newer firms. But the more traditional firms, they do have a library, and they can have quite a big library. I still remember last time, this Gopal Sri Ram's firm has got a very thorough library, and even his current chambers, he does have a very good library as well. I work with him on some cases now also with Dato Sri Gopal Sri Ram, and he's still a believer on having a very thorough library. Okay. And yeah, back to your question, actually, research is actually very important. And when you go before a judge, you have to have a thorough research over all possibility, of a case scenario that you're representing your clients. And it is very important because if you face a judge who's very familiar with that particular area of law, then you most likely are going to make a fool out of yourself if you're not prepared, or you missed out on some points of your research when you're trying to argue on behalf of your clients. Yeah. Okay. I hope I answered the question. Is there any other question?
Yes. So the next question in the chat box is from Irene, and I see that she raised her hand. Irene, do you want to unmute yourself,
Irene,
or do you want me to ask for you?
It's okay. I can ask now.
She wants to be a litigator, so she has to ask.
Good morning, sir. I have two questions actually in regards to employability. You mentioned earlier that we need to get good grades. So
Yes.
I was wondering that besides getting good grades, is there anything else that we can do to boost our employability? Since you mentioned earlier that webinars and mooting competitions may not count as much in our resume. And my second question is, do employers look at our grades more, or do they look at what subjects we actually took during our law school?
Okay. I think grades are very important, particularly for pupillage, because it wouldn't be fair to the firm to judge you on your experience, because there's no way you can judge a freshie based on their experience. You know what I mean? Because they would hardly verify it. They say, oh, did the person work in Metro Jaya before or something like that? It doesn't add to the practice. Or does that person, work as a barista in Starbucks before, because you're so fresh. And then you did some internship and so on and so forth. And then we as practitioners, we know that a lot of internship, especially now with virtual internship and so on, most of the time they are at home now. What they do really cannot be verified. So I have some interns actually applied to our firm. In the past, they already done like 4 or 5 interns, on a monthly basis in different firms, or even some firms in the UK. I don't think it adds any value, because we know how interns work. And while it does show some initiative, it's a plus point, but it won't be a plus point. It was just a plus point. So the results, I'm not saying that when you got bad grades, you won't get a job. I think you will still get a job, but it may be more difficult. And if you're talking about working in a premium firm, firm where you can actually learn more, firm that will catapult you to be perhaps a better lawyer in those firms, you need better grades, because it is so competitive. Like, for example, there's always a saying, it's just like the article I actually just sent to Yvonne, your organizer, that I just received from Lincoln's Inn yesterday. They talk about how the best job in the world is a barrister. And I think that was their first issue for bar students in the UK. And there's this write out by this award, a bestseller. Actually, he or she was anonymous. He put there as a secret barrister or something like that. But he or she is actually a bestseller, Sunday Times bestseller in the UK. So he wrote something to say that I take his research. I said that in order to become a barrister, for each position in a chamber of barrister, you got 300 people applying for one. So 300 to 1, you can just imagine how competitive you would be. In Malaysia, I don't think it's 300 to 1. I do not know the statistics, so I won't share it here. But I believe there are quite a lot. Like, just like from my own experience, let's say I've got a chambering position. Let's say I'm going to take in one chambering this month. I would easily have more than 100 applicants. Okay, more than 100 applicants for just one position. And you can imagine the HR will start to filter, and then I'll have a committee to go through it. If your grades are not good, you wouldn't even pass that stage. Okay, I wouldn't say that my firm is the most prestigious, but we are one of the perhaps top 10, top 12 firm. But can you imagine if you're looking at the top 5 firm, or one of the leading firms, or the large firms, and they're looking like for 5 pupils, and there are like 500 applicants? What are the chances that if you got bad grades and you attended many internship, they will take you seriously? You understand? I'm just being very practical. However, I'm not saying that you won't get a job, because there are plenty of firms. There are thousands of firms in Klang Valley alone. And I've got friends who set up their own firms, small firms, they are decent, they're good lawyers. It's just that their path wasn't towards setting up a large firm. So they have one-man show or two-man show or one lady or two-lady show. And for these people, they're desperate for pupils, because every student that come back from UK after the bar school, they aim for the top 20 firms. That's their first choice. Apply until they fill everyone. Then they go to the second tier or the medium-sized firm. Then they apply. When they fill everything, then they go to the small firm, or through friends or father's friend, whatever. Hey, your uncle, got a firm or something like that. Then you'll get a job. You definitely get a pupillage position, but it's just that you will be disadvantaged if your grades are not great. That's the reality of life. You understand? And Malaysia, being a developing country, we are already less concentrated on results. If you're going to Singapore, you're going to Hong Kong or UK, especially UK, you want to go to the Magic Circle, you don't get a first class, and not just first class from the top university, at least the top 10 in the UK, you can forget it. You won't get a training contract. You may end up working as a general counsel in a company. You won't get a training contract simply because there are so many first-class students from the top university, from Oxbridge, from the LSE, from UCL, all the top universities. They have got so many first-class students, and they will be eyeing all the Magic Circle training contracts. And if you are even 2-1, you don't stand a chance for the Magic Circle unless you're a 2-1 as a second degree. Maybe you're a first-class engineering degree. So they are looking at you. Perhaps you can go into an arbitration stream, you can do construction cases. Then they may consider, like a friend of mine, he went to Alan Overy. He's much my junior. But when I was staying in London at that time, he was trying to get a training contract because he wanted to be a PR in UK. He has been in UK for like 8 years. He needed 10 years to get a PR-ship. So he was asking for my advice how to stay in UK. I said, become a lawyer, But you know what is he? He's a concert musician. He's a first-class musician from the London Academy of Music, or is it called Academy of Music, or London's? It's one of the top music schools, and he's a music prodigy. He's got first class, he's got masters as well. So he changed to become a lawyer. He did a conversion course, and he got a place in Alan Overy as a pupil. And as far as what I know, if you do a normal stream to become a lawyer to get into Alan Overy or Freshfields or Clifford Chance, you definitely need to be first class, and not first class from the top uni, Oxbridge, Oxford, Cambridge, maybe Durham, maybe UCL and LSE. If not, you don't stand a chance to get a training contract during my time because it's very competitive. But a music student managed to get in because he got first class all the way for his music. And they always believe, let's say you got a mathematics degree or something, from Oxford, your first class mathematics degree, then you decided to become a lawyer, you do a conversion course, they may take you also, because some of these recruiters in all the top firms, they like variety. They want to try out someone who is able to get first class in some other field, so that if they say that if their mind can be so technical and such a musical genius in some other areas, maybe they can be a legal genius, you give them a chance. Then they don't even need a degree, just a conversion course. And my friend is working in Alan Overy. Later, he was transferred to Shanghai, he was transferred to Beijing, he was transferred to Hong Kong. Of course, now he's retired since I think he made enough money already as one of the senior lawyer in the Magic Circle firm. Yeah. So study hard, good grades. I think you can't run away from that. It's just like, I still remember, I tell you this story, which is very funny. We had a career fair in UM, many years ago, where that time I was a junior partner. Then I went to man the booth, trying to attract pupils, to join the firm when I was in this firm, and there's one prospect who came to actually we had an open interview as well, because we were taking pupils or interns at that time. And there's this applicant who came, and she's got a third class degree. And then she did not submit her CV, but she asked me, she said, why is it that in your firm you state that you only take pupils with a second upper. At that time we had, I'm not sure about the policy, I need to check with my pupillage committee. We used to have this policy that we only take pupils with a second upper honors degree. So it's 2-1. 2-2, we don't take them as pupils already. And there's this third class, I think she studied a London external, she came and she said that, why are you discriminating against people who get bad grades? So I don't know how to answer her, because I was thinking that, well, if one day you actually run a firm or you run a company and you got 100 applicants, do you purposely choose a third class? You don't, right? So if you're in a position to choose, you got no choice but to discriminate because you only want the best for yourself. You get what I mean? It's just like when you want to look for a husband or you want to look for a wife, if you've got a better one, why do you want to choose a worse one? There's no reason for you to choose her. So I couldn't answer. She caught me by surprise. It's just like, if I can afford a Ferrari or a Lamborghini, why would I buy a Kanchu for the sake of buying a Kanchu to discriminate against a small car? I don't, because I can afford it. So the same thing goes with a law firm. If a Magic Circle has got 100 first-class students from Oxbridge, LSE, and all those applying, why would they offer a third-class polytechnic student to come in for the reason of challenging themselves to say that they don't discriminate between results? They don't have to, because we're a commercial firm. We only want the best brains to earn us as much money as possible. You know what I mean? So it's a commercial situation. And if each one of you are in that position, I can tell you, you do likewise. If you got an option to choose, then you choose. It's just like a celebrity. A celebrity, wow, they got so many Instagram followers and all those things. If they really one day want to choose a husband or so on, of course, someone in a position who can actually choose, they've got more options. Why would they want to purposely choose someone who's very low quality? You know what I mean? You don't. So it's the same thing, like not just law firms, like large companies like Petronas, Shell, and all those things. They also have a certain requirement for, one very good example, I can tell you this. Consultancy firms like McKinsey, like Bain, like Accenture and all those things. More so for McKinsey and Bain and Boston, Boston Consulting. McKinsey, as far as I know, will only take first-class students. But they may take first-class students from any field to train you as a consultant. And you can't go to McKinsey and company and tell them, hey, I got third class, why do you take me? You're discriminatory, It's like, it's a commercial company and their choice to choose the brightest brain, just like Khazanah wants to choose the brightest brain. Talent Corp wants to choose the best brains. So law firms who are in the position to choose because they are so strong, they got so much work, they got so many good lawyers, so they are able to choose. Of course, they will choose the best students. You know what I mean? And that's why that lady caught me by surprise, because I just answered her, why not? Why not only take 2-1? Because that is our policy. Because she said that we are terrible, we are so discriminatory. What makes you think that third class are not good? And then you know who she cited? She said, I heard Kapil Singh was third class also. And Kapil Singh became a very good lawyer. Then, can you imagine you missed out on Kapil Singh if she comes and wants to chamber with you? You only want to take a 2-1. Kapil Singh had a third class. Why do you? I was thinking, that is maybe 1 in a million exception. You know what I mean? If everyone wants to go for the lowest grade, then why do we study in the first place, right? Better fail all your exams, or even better, don't pass a SPM, don't pass a STPM, don't care lah. Because when you fail all your grades, you just go to an employer and tell you, why do you discriminate lah? You should take these people who failed because you have to be fair to us, because we are poor, but you fair to us. You can't do this, because we are a commercial firm. We just want the best brains to work for us. Not to say that the best brains will turn out to be very good lawyer. Okay, that one I need to caveat myself. And what the lady said is correct. Kapil Singh may have a third class, but he turned out to be a very good lawyer because he is an exception. So you can't use an exception as a norm. Because if you are a first class student, chances of you to become an excellent lawyer with good analytical brain is there. If you're a first class, that means you have worked hard, you've been disciplined, you have got your straight A's in SPM, you got your straight A's in STPM, and then you got first class. Chances of you succeeding is very high. If not, why your parents ask you to study hard? Obviously, you want good grades, right? So can I argue with that lady to say that, why do you discriminate against those people who got good grades? So are you going to scold those people just because they got first class? So first class are supposed to be jobless. We only take in third class to those people who actually worked hard. You understand? So my answer to you is that jobs will be aplenty, but you want to get to the top-notch firms, whether in Malaysia or overseas, get the best grades. That's why I say, if you can, this is just my personal view, go for those subjects that you think that you can actually excel, so that you end up with a first class. If you don't get a first class, at least a high 2-1, a very high, whether it's CPGA, they call it whatever, the score, get a very high one at the borderline, so at least you can convince your future employers. Once you get through that, you get good training, good firm, then when you are senior, 5, 6, 7, 8, 9 years of practice, then you may be on your own, you may be in a partnership, or you may be a partner in a large firm. Then the results is no longer important. That's when the experience and your grit and your persistence and your persuasive skills and your analytical skills, all those come into play. And you may end up becoming a kapal singh. Doesn't matter what grades you were when you were in law school. But the first year that you get a job, you need the good grades, because nowhere else I could gauge someone whether the person is good. But all things being equal, of course, the easy way out is to take the best. Am I right? The strongest, this is a reality of survival fitness. If you watch Squid Games also, you want to go tug of war, you want to get the strongest people, right? If not, chances of losing is there. If you're given a choice, of course, you're going to get the best people. Okay? Any other question?
Due to time constraint, should we get the two people who raised their hand quickly address the two questions from them, and then we wrap up for today's webinar?
Sure.
Perhaps Adriana can go first.
Hello, am I audible?
Yeah, hi. It's a bit soft.
Okay. Hello. Thank you very much for the really enlightening and entertaining session as well. I have two questions. The first one is essentially a follow-up to what you've said. Essentially, okay, so assuming that we all have first-class grades, assuming a huge assumption there, then how else do we stand out from our fellow first-class graduates? Do internships really not count at all?
First class is really very good already, so you don't have to step ahead of other first class. I think if you get a first class from any university, you already have the advantage. But of course, in a very unlikely scenario, everyone has a first class. Then of course, if you're a prospective employer, you also look at consistency, right? So you're going to look at the A levels, you're going to look at the SPM. I don't think you will look until UPSR, but at least SPM, the A levels, to see this person is actually consistent or not. Or is it a fluke? You got a first class because somehow last minute you got some leak question or whatever, they managed to do well. But if you consistently are top students, you're consistently straight A students in SPM, A levels, of course you have advantage over someone who is up and down. Because it also shows someone matures later, someone matures earlier, but someone can be inconsistent. So even as a lawyer, you do not want a lawyer who is inconsistent. 1 year you perform well, next year you perform not so good, then you become a poor performer. Then employers have to think of ways to get rid of you because you are not consistent. But some people from very young, they've always been having good grades. So chances of these people succeeding is very high because they have a very good upbringing. They already have the discipline to do well from very beginning. So chances of them dipping after they get their first class is very low. So if you ask me, just based on the CV, you look at the grades first. Consistency matters. But if you're not so consistent, at least when you're given a chance for a degree, get the best grades that you can. Of course, other things help. So let's say you're a school captain, you're a debating team captain, and you represent your university, just or whatever, those mooting, you're a champion, all those things. It helps, especially if potentially someone wants to recruit a litigator. You want a good debater as well. Someone with, good debaters have an analytical mind as well. They stand on their feet as well. So those things helps, okay? But of course, the experience working in Starbucks, barista, and all those things, actually, if you ask me, don't even put that in because it doesn't help. Okay, what does it help? No, perhaps during pupillage you can do some coffee, whatever, but it doesn't really help. Like a salesman in working in a optical shop or something like that. I've seen some of those CVs. Actually, don't put that. Just put what matters. If you have no experience, it doesn't matter. You have no experience, but you got good grades. But you're looking at pupillage position anyway. So pupillage position, they generally look at grades. But of course, I've got an exception. I've got a pupil who last time, he has got work experience. He's worked overseas before. He was an executive in overseas and all those. Then he's decided to study law. And that helps a little bit. And that will actually tweak towards the mindset of you have to have very good grades, because his grades could be above average, but not the top grade, but he has got excellent experience. For example, he has been, let's say, previously has been a chartered quantity surveyor, or has been a professional engineer, or he's a professional chartered accountant, and then later he got a 2-1 degree, for example. Then I may opt that from a fresh first class. You know what I mean? If you get a chartered accountant, which potentially may have their own circle of clients and all, and you got a 2-1 degree from a good university, and I think that one is a very strong candidate. You know, because you have excelled in other areas. You could be a first class engineering student, and then later you come to me and I say, yeah, I may take you as a priority over a fresh first class student, for example. But how many of those people are around? Actually, not many. Okay, those with professional chartered surveyor, chartered accountant, and all those things, who wants to become a lawyer later on.
My second question is a bit more casual. So it's just out of my own curiosity, right? Because you were saying you didn't regret going to litigation, even though you didn't have exposure to other areas.
Yeah.
Are you saying that because you've come this far and have invested this much? Or do you say that because you genuinely don't regret it?
No, I genuinely don't regret it. It's because I think I've shared with you before. When I first started practice, and even the last 2 years, when last 2 years considered, we are quite badly affected, the country, then I realized that, in fact, those people who work in my team, they feel the assurance that in difficult times, we are the most secure. And I'm very thankful and grateful that I chose this area, an area where when everyone is down, you're always ahead. So I cannot regret, because of course it's the right decision. Because if I choose any other areas, I may regret it, because I've seen some of my colleagues and I've seen some of my friends, during bad times, either the Asian financial crisis in the 1990s, or even the other crisis, or I can't remember what crisis. Along the way, every 10 years there's some recession or some downturn, or even the pandemic the last 2 years. They are badly affected. Some of them have retrenched their lawyers. Some of them, they just don't have work, and they feel very insecure with the commitments and all those things. And then we as litigators is like, we are positive. It's like, recession, we do even better. And to be absolutely honest, the last 2 years, I did so much better than 2019. That means 2020, I did better than 2019. 2021, I did even better than 2020. It's actually a record year for me. So during this time, I, of course, regret is not in my vocabulary, except it can be quite stressful. Okay, see how you manage your stress, because if you do litigation long term, many of the litigators do have high blood pressure, because it's too intense. We need to fight in court all the time. We need to strategize. We need to outdo one another. We need to have tactical maneuvers all the time. We need to think all the time, and it stresses us sometimes. But the rewards are definitely better than any other areas for security as well. Yeah.
All right. Thank you, sir. I really appreciate it.
Sure.
So let's proceed to Muhammad. Is Daniel's question?
Okay. Hello, Mr. Leonard.
Yeah, hi.
My name is Daniel. So I have only 2 short, silly questions.
No silly questions here, yeah.
So I hope I'm not taking a lot of your time. So my first question comes from my confusion on the division of work from a litigator and other different types of lawyers. So let's say that a firm has 2 departments, yes. One intellectual property department and one litigation department. And then a matter is brought to the court which concerns the issue of intellectual property.
Yes.
So who will be in charge of being an advocate for that case? Would it be that intellectual property lawyer, or would it be that litigator? And if it is the litigator, what role would the intellectual property lawyer play? And then my second, that question first.
Okay, I'll answer that question first. Okay, I think this one is a good question for me, because my firm has a very strong litigation intellectual property practice as well. We have intellectual property IP partners. And in the past, also we had intellectual property partners, but not all of them actually go to court. So we have intellectual property partners that are also litigators, but they specialize in intellectual property disputes. So if the firm has got intellectual property practitioners, but they are not intellectual property dispute, they are maybe trademark prosecution, that means registration of trademarks, those are lawyers. They're not litigation like patent disputes and infringement passing on disputes can be quite complex. They may actually work with the litigation department. But our firm has reached a stage that unless it's necessary, some of the counsel work that I used to in my firm, I am actually the senior counsel in the intellectual property disputes while we have intellectual property partners. But after the intellectual property department gets more matured, they have got their own litigators, then they don't need my services. So basically, you can go directly to the, like currently my firm is, we have sufficient and able intellectual property dispute lawyers and partners to actually go to court themselves, because it's a very specialized field. It's a very specialized substantive law field that while I know, but they know even better than I do. So it's better for them to argue. But if they need the experience, let's say for advocacy, they need the procedural experience, I can be a senior counsel to argue the case, let's say in federal court or in court of appeal. So it does help. But it is depending on the firm, usually a large firm, ours is a medium to large firm, we would have specialist intellectual property dispute lawyers. While I've done IP, but of late, I hardly do any. I do other disputes, I do other commercial disputes, other corporate disputes, I do construction disputes, I do employment disputes, but I don't do IP disputes anymore. Yeah. Your next question?
Okay, thank you, Mr. Leonard. So my second question is, because you mentioned just now that aside from only relying on our local recognized judicial precedents, might as well also sometimes be a little bit creative and relying on other jurisdictions.
Yeah.
So my question is, for example, like if there is a new issue in appearing in the court, which there's not a lot of precedents, local precedents, such as an issue on mandatory vaccination. So can we refer to non-Commonwealth law reports or non-local law reports, non-common law reports, such as, for example, the United States law report, and put it in the bundle of authorities and citing it in the submissions? Can we do that, sir?
Okay. No one can stop you from putting any precedents that you want to argue. Then it all depends on the judge. You don't put it for the sake of putting it, but if, like what you say, there is just no authority on that particular area, then it's fine. But you don't like actually got authority in UK and Malaysia, but you think you're very smart, you got LexisNexis or whatever, search it, or go Google for that matter, you're going to take some American, South American cases, some African cases, you're going to throw it in, you'll be thrown out. Because, first of all, any outside Malaysian cases, they're only persuasive. Why it's persuasive? Because it will only be fair if, let's say, there are existing laws created by the local judges in Malaysia that we use it as our judicial precedent that is binding. The federal court is binding. But if, like you said, no such law has been created yet, then they'll be more than willing to hear what Singapore has decided, if Singapore has done it before, Australia, Hong Kong, and England first. Then, if let's say no Commonwealth jurisdiction has actually decided on this point, then you go beyond that to the civil law jurisdiction. You go to the US, you go to France, you go to Germany, you go to Holland, or you go to South Africa, actually Commonwealth. And okay, not forgetting, actually many times we cited Indian cases from the Indian continent as well, or Sri Lankan cases. So you only cite those cases if there's absolutely no cases. But if you have not thoroughly researched, you think that you're a smart aleck, you go and search all those cases which are quite similar, but they also got Malaysian cases. You think you're very smart, you go and cite US cases, you'll be thrown out, perhaps you'll be scolded as well. And you'll be embarrassed in open court. You say that what we're trying to prove, you think that you got very good research skills by clicking on Google, it's something like that. Because now a lot of things can be found from the internet, and the judges do that as well. So they know, like last time when Ram was still a judge that time, He has got very good library, and he used to cite a lot of Indian cases and US cases. I've heard him citing in court as well. But that is, he thinks that it adds up to him trying to create laws from guidance from even outside the Commonwealth jurisdiction. So there are some judges like that, but there are some judges who are not so bold to actually test out other laws. They even throw out those Singapore cases as well. So they say that, we are not following, persuasive or whatever it is, you put it in, but I'm not persuaded, I will still follow the Malaysian cases. So it depends on the judge at what level as well. And you need to at least be true to yourself that you already done a thorough research on Malaysia. Malaysia, after so many years of judicial precedent, we have most things argued now, but there are some new areas, of course, we have not. Like competition law, when we first started, we did the first competition case in Malaysia. We had to rely on all the EU cases, the EU Competition Commission. And most of the cases we cited is also from EU, because Malaysia got zero case at the time, because we did the first Air Asia and Mars case in High Court, and now has reached Court of Appeal as well. So, okay, I hope I answered your question. Yeah.
Yes, they do answer. Thank you, Mr. Leonard.
Yeah. So there are only this few, the rest are not too shy to answer, is it?
Because we have like time constraint. Yeah. So thank you, Mr. Leonard, for staying with us up till now. That's the end of our Q&A session, and we hope that you have enjoyed sharing, and that all our participants today have learned a thing or two out of the webinar session.
Yep, I hope so. You're going to take a photo, is it? You want Aaron to on the camera?
Yeah. Shall we proceed to the photography session now? And can I request everybody to turn on your cameras so that we can get a group photo with everybody in it?
Everybody pakai baju dulu. Oh, finally, I see more people now. Yeah. It's the first page. How many pages?
There are 4 pages.
Oh, there are 4 pages.
Yeah. So,
many still not on.
Just quickly turn on your cameras, and then we won't take that long. Yeah.
Wow, you see so many, but everyone is so shy.
Yeah, everyone is turning on their cameras already.
Anyone overseas can put up their hands. Anyone overseas? Tada.
Okay. So
There are still the last 2 pages not on their camera.
Yeah, not all. From the 3rd pages onwards, they didn't turn on. Yeah. So I'll say 1, 2, 3, okay? Yeah. So 1, 2, 3. Next page. 1, 2, 3. Okay. Yeah. So I've taken all photos ready. Thank you, everyone.
All right. Thank you, everyone. Have a good weekend. And study hard.
For other participants, I'll see you at 1 p.m. later for our next session.
Okay.
Thank you, everyone.
All right.
Thank you, sir.
Enjoy yourself. Yeah, enjoy yourself, everyone. Okay. Thanks for participating. Thanks for the organizers as well. Thanks, Yvonne. Yeah.
Thank you, Leslie.
Yvonne, yeah. Okay, bye all.